welcome to Chapter 1 in your commercial law class. Chapter 1, as the name suggests, is a very general introduction to contract law. But before we delve into the details, an understanding of the laws that govern contract transactions is important. Contract law can be divided into two broad categories: common law contracts and statutory contract law, specifically in this case the Uniform Commercial Code. Each area is equally significant in contract law. With the internet and new technologies bursting onto the scene and changing every day, the law is still developing, with the courts and the legislatures setting standards and passing statutes in an attempt to regulate how we do our business in that environment. That is why understanding the basics of contract law and the U.C.C. become increasingly more significant. The two foundations for modern contract law are, again, the common law and statutory law. Common law is created by judges, and statutory law is law that is passed by legislatures, whether it be state or federal legislatures. We're going to talk in depth about these two sources of law as we move through this semester, but I just want to give you a general overview of these two types of law, these two sources of law, and a very basic understanding of when each source of law is applied. And again, as we move through the semester, we'll get a much better understanding. Now, as you may or may not know, our American system of laws is based on the English system of law, called the common law. Both the English system and our system is based on the concept of stare decisis, which is basically a system of precedents. And to give you a little bit of background, if you think about sort of medieval times in Europe, the law basically came down from the landowner, the local landowner. And as we'll see throughout the semester, that really has a chilling effect on business. Businesses hate uncertainty. And the problem with this system of English law was that if you went from one landowner's area to another, you didn't really know what the laws were because the landowners were different people. And so as the English system developed, what would happen is the judges from the royal courts in London would actually ride circuits. Think of circuit courts, right? They would go out into the countryside and they would act as the judges in these more rural areas. And every time they made a decision, they'd write it down. And so when similar cases came up in the future, they could look back to these writings and see what the facts of that case were and see what the precedent was. And so what happened over a period of time is people were able to predict outcomes based on factual situations. They created certainty, which certainly at least helped business, and it also helps in criminal law and equity, as we'll see as well. So essentially, stare decisis provides some level of predictability in the judges that are, or the decisions that are made by judges. But as the world changes, precedents often adjust to the changing needs of society. But what I want you to understand is setting and following precedents is the foundation of our American system and is known as the common law. The common law of contracts, therefore, is law based upon English traditions created by judges to settle disputes arising out of contractual relationships. So let's talk briefly about case law. Case law is derived from judge-made decisions interpreting the various types of law, which include common law, which we've just talked about, constitutions, statutes, administrative law, procedural rules, and both on the federal and the state level. Case law builds its decisions based upon past precedents, upon which judges rely. Now, because we have different court systems throughout the United States at the federal level, and then various courts at the state level, and each state has its own court system, we have to determine whether or not the case law is mandatory authority or persuasive authority. Mandatory authority is law or case law that a judge must follow, while persuasive authority, the judge gets to decide whether or not they follow it. So a highest court in the state Supreme Court, would be mandatory authority for all of the courts within that state. But a case decision made by a Supreme Court in a neighboring state might only be persuasive authority for a North Carolina court. As we move through the semester and as you read through your text, there'll be different cases used to illustrate these legal principles and related to the topic in each of our chapters. In addition to case law, I want you to be aware of something called the restatement of contracts. As a response to the volume of case law being decided in the country, a group of lawyers and judges and professors in 1923 got together to form the American Law Institute, and they created what are called restatements of law, in this case the restatement of contract. And these restatements basically take the holdings or the principles espoused in cases and put them into a textbook form, so they're easier to search, easier to find, easier to understand. Now, because these are not case holdings, restatements of contracts are persuasive authority, not mandatory authority. Important to keep in mind, but they are very helpful when you're trying to determine what a particular principle means, says, or does. Now, on to the Uniform Commercial Code, or U.C.C. for short. As commerce developed from a largely local endeavor to a regional and then national endeavor, a set of uniform national standards was needed, and uniform is the key word here. Uniform laws are sets of common denominators that are put together and suggested to the states. And again, we're trying to create certainty here for merchants across the country, so they know if they have a business in New Jersey and they want to sell to somebody in California, that there's going to be some parity in the law across the land. But uniform laws must be adopted by a state legislature to become law in that state. The good news is that the U.C.C. is one of the more successful uniform laws across the country. All of the states, with the exception of Louisiana, have adopted some form of the U.C.C. So merchants have the comfort in knowing that they can enter into contracts with certainty and reliability just about no matter where you are in the United States. We're going to concentrate primarily on Article 2 of the U.C.C. In this class. It covers the law of domestic sales in the United States, and when a seller sells or a buyer buys, some form of U.C.C. Article 2 will apply, again, except in Louisiana. Now, we're not going to spend a lot of time on the U.C.C. right now. In fact, the first several chapters of your text deal with the common law. We're going to work on the basics, the foundations of contract law before we move on to the U.C.C. But rest assured, later on in the semester we will dive in great specificity to the U.C.C. For right now, what I want you to understand about the difference between common law and the U.C.C. is when it applies. Generally speaking, if we are dealing with contracts where two individuals, non-merchants, two individuals are involved, and the contract is for services only, we're going to use the common law to interpret that contract. If, on the other hand, a merchant or merchants are involved and the sale of goods are involved, we'll use the U.C.C. to interpret that contract. Now, that's a very basic and broad overview. We'll dive into both of those concepts as we move through the semester, but for right now, that's what I want you to understand. Another thing we're going to spend time on again later in the semester are other consumer-based laws that have the aim of protecting the public. The most notable of these is the Magnuson-Moss Warranty Act passed by Congress. We're going to spend a whole chapter discussing this later on, but suffice to say for now, when you purchase a good or product, it usually includes some warranty language, either full or limited, that is mandated or covered or governed by the Magnuson-Moss Warranty Act. I also want to talk to you just briefly about e-commerce and the law. Times change, and contract law is one of the most quickly developing areas of law because of e-commerce. Since the law was lagging behind technology, Congress and some legal scholars got together and took on the task of setting some parameters for e-commerce and transactions arising in this new electronic society. The result are some new statutory laws: the Uniform Electronic Transactions Act, or UETA, the Electronic Signatures in Global and National Commerce Act, or e-Sign, and the Uniform Computer Information Transaction Act, or UCITA. UETA was designed to address two specific areas. Number one, the retention of paper documents, which could be changed into electronic ones, and two, the effect of electronic signatures on documents, whether from an original document or an electronic one. The result of UETA is that an electronic document is now the equivalent to the original paper counterpart. The law also validated the fact that the use of electronic signatures are equivalent to an original signature on a paper version of a document. In 2000, Congress passed e-sign, and this is a federal law that lessened, again, the barriers between the paperless and the paper-driven worlds of the past. E-sign specifically allows the use of electronic technologies to form and sign e-contracts and e-transactions. Companies can now validly contract online in a paperless or electronic world without the impediments previously associated with electronic transactions. There are some important caveats, which we'll talk about again later in the semester. Now, U.C.C. is relatively new. It's been adopted only in Maryland and Virginia. Only at this point, it is one of the more controversial uniform laws out there. Hasn't been adopted widely. I'm not going to spend a great deal of time on that, but I do want you to know it exists. Before we move forward, I do want to draw your attention to Exhibit 1-3 in your books. It helps you with a chart there on applicable laws to contract transactions. You may want to take a look at that. Okay, let's wrap up Chapter 1 by talking a little bit about where to find or where to research contract law. Figuring out where to find helpful information either online or in a library can be daunting sometimes. And before we settle into learning some more of the basic concepts in a contract course, I want you to know about these resources that will help make your journey a little bit easier. We've already talked about the common law, statutes, and the restatements to help you in understanding contract law. There are some other resources to explore which should help you assist you in finding the law and drafting documents for commercial transaction. First, let's talk about legal treatises. Legal treatises are single or multi-volume sets of books that are devoted to the study and interpretation of a specific area of the law. In contracts, the two most famous legal scholars are Corbin and Williston. One taught at Yale, one taught at Harvard. These two treatises are quoted extensively and used by courts sometimes as persuasive authority. Next, let's talk about hornbooks. Hornbooks are single-volume treatises and used a lot in law school settings. We used to use them actually here in the paralegal program. The most notable hornbooks on the U.C.C. come from James White and Robert Summers. It's called White and Summers Hornbook on the U.C.C. Finally, law schools and state bars publish journals. They're scholarly journals from law school known as law review journals. State bar journals both provide research papers on specific issues. They're written by law students, attorneys, professors. They're not as detailed as hornbooks, but they can help you in very specific areas. You can also look to legal encyclopedias, state practice series form books, some of which we have in our law library. And of course there's a myriad websites out there, both from the government, academic, or fee-based. We have access to some of those, specifically LexisNexis, that is available on the LRC website. So that's a general overview of what we'll be looking at this semester and a general overview of contract law. In summary, what I want you to understand is that contracts is one of those areas that touches literally every day of our lives. When you lease a car, when you buy a car, when you buy a house, when you purchase or download software, all of those things involve contracts, involve warranties, involve the Uniform Commercial Code and the things we'll talk about this semester. The other side of that coin, though, is that most of us, despite the ubiquitous nature of contracts, simply ignore them unless there's a problem. And sometimes we even ignore them after there's a problem. Because of the pervasive nature of contracts, it's important for you to have a solid foundational understanding of the basic rules and laws surrounding the negotiation, drafting, interpretation, and enforcement of contracts. You will use these in your everyday life, whether you end up in a law firm or not. The simplest tasks in your life involve contracts, sometimes without us even recognizing. Cross-pollination in this area is massive. You'll use what you learn in commercial law in most of the other classes you'll take while you're here at Coastal. The tendrils run into civil litigation, estate planning, family law, employment law, intellectual property, corporate law, just on and on and on. So this is an important class for you. I urge you to ask any questions you might have As always, you can contact me during virtual office hours, real office hours, by phone, by text, however you need to. We'll see you next time, and we'll talk about Chapter 2.